Madam Speaker, it seems like just yesterday we were debating this bill, so it's a great pleasure to be back up and continuing the cross-party support fest that we're having this afternoon, because we have another bill which has been well received by the House and well supported across the House. So it is a real pleasure to be able to speak to this particular bill. This one is, of course, one of the many bills that's come through the Justice Committee. I wanted to thank the members of the Justice Committee, the busy and effective Justice Committee, for their ongoing collegiality and hard work as they work through these bills. It's interesting because we had actually a number of bills in this space, and as the previous speakers mentioned, the bill was actually brought to the previous Parliament just before it dissolved last term on 29 August and has made its way through to this Parliament, so it's been picked up by Paul Goldsmith. And one of the things I wanted to point to was throughout the debate on this bill, it's one of a few family violence, sexual violence bills that we have considered as a committee, and it became known as the Litigant Abuse Bill because of the title. We had very similar titles. We had the Family Proceedings Dissolution for Family Violence Bill, we had the Victims of Sexual Violence Strengthening Legal Protections Legislation Bill, and then we had this bill. And because of some of the confusion around which particular bill we were addressing, this bill became known as the Litigation Abuse Bill. And that's important because one of the changes that the Select Committee actually made throughout the process was to change one of the terms in the bill from preventing abuse of the court to what it actually is intended to do, and that is abuse of individuals, harassment of others through litigation, through use of the court's processes. And that's the real intent of the bill. It's to protect victims of family violence and to protect individuals from harassment, from intimidation, from annoyance, from estranged spouses or former partners or other family members by using and abusing the processes of the court. So that's the key part or the key purpose of this bill. The other thing that this bill does, Madam Chair, is it made a couple of further changes. The bill originally removed a provision around vexatious litigation, and we decided to actually put that, make sure that term wasn't removed from other pieces of legislation, because it's still important that those processes or that vexatious litigation can be prevented. This particular piece of legislation won't prevent that, because that's the instance when you are maybe a self-represented litigant, or you are repeatedly processing applications on your own behalf and you become vexatious, not necessarily with the intent to abuse or harass others. There were a number of submitters who thought the bill didn't go far enough and who made some very strong and valuable submissions around whether or not we could expand the bill to cover off instances of stalking, because New Zealand doesn't have a stalking law. And it's interesting because I think that was met with a lot of approval across both sides of the committee, to the point where I'm sure it would be able to turn to say that some of our members were considering drafting a members' bill around stalking, and then lo and behold, Jenny Anderson beat us, put us at the post, to use a better analogy, before the end of the year. And then, of course, Minister Goldsmith has also indicated that the government may be interested in picking up a stalking bill as well. So there is some further good news to come from this particular piece of legislation. It's been well supported across the House. I look forward to seeing its passage through second reading, through committee stage and through the third reading, and with that I will commend it to the House.
Don't you love it when you put 1.5 times on the speed for the footage so you can cover all the information in a narrow piece of time?
There are some MPs who you might need to do it as a double speed just for it to be interesting.
Simeon Brown,
or if
Andy Foster, you can only do it 1.25 because he speaks too fast as it is.
So I think James is a former Marine, right? Is he a former soldier, a Marine, or something, James?
I don't know. I do know. So I've met James in person twice. Yes. Both of them were at the Justice Select Committee, and he did sit there. And he seems to be. He is partly interested in trying to make It's in the Ballot come to Timaru.
Oh, great! Yes. So,
yeah, I know. There's a lovely thing called the Cock Straight in the Way.
Looks like a
you
good
swim across the strait. You'll be fine.
I'm not taking this computer. I'm not swimming it.
Well, no, you just put that in a waterproof bag and you float it behind you. It's how they do it when they do crossings of the strait or the lake or all that.
Considering the entirety of the Blue Bridge are a bit questionable at the moment.
You just have to coat yourself in petroleum jelly. It's what long-distance swimmers put on themselves. Petroleum jelly and sometimes olive oil to keep away sharks. The more you know.
You know, guys, in terms of this protection bill, right, I think it's good because there's one section of it that protects the victims by remote. I think it's great because, if you're a rape victim and you're being traumatized, you don't want someone where you have to face the rapist.
I mean, this one's more about family violence, but I mean, that is true about some rape. Like they said, particularly with children, the most common rape is usually someone associated with the family, such as the worst example to say here is an uncle.
Yeah, face to face even more, So that's related to this one, isn't it? The one where he says that some litigants who are rich or whatever who has time or even go through legal aid and then keep suing the victim and then just to create stress, like, oh,
or
you know,
or, or,
whatever.
or doing what is known as called repeatedly putting in ex parte orders. It is a common one that I've heard of, and I've heard of it in both directions, where one person would be, and I've also heard work and income have actually, in some case managers' bad interpretation of it, and sorry, this is my vendetta against wins, is that unless you have a custody order, they won't hand you the sole parent support benefit. So they will tell you to go and file an ex parte order. And the problem is the one party who keeps filing it gets it through, but the other party cannot file an ex parte order in response back away or something. It's a very vicious cycle, considering an ex parte order is used as emergency. And I know Aronga Tamariki were doing that to uplift children as well, because it took so long for things to get done through the proper systems, because our systems became too backlogged. And so, yeah, so some people keep filing those ex parte orders when which could be seen as an abuse of the system, because they're denying the other party the chance to even have their say, or even have the record set straight, or whatever you make it.
Right. So it seems like whoever just keeps attacking the other person gets through, and then the other side, we just have to be on the defensive and say, well, I can't refile anything in defense because he or she was first in, into the whatever.
Yeah, and I mean, some people sit there and do that. Yeah, I mean, some judges see right through it. Others don't. I've been told RMA commissioners are very good at seeing that bullshit. I've been told that. Yeah. Yes, we do know that, because Johnsonville Market went through that with our resource consent. And the thing is, the main litigant who was trying to stop it basically looked like a big time idiot and a bully, and the RMA commissioner saw right through him.
Right.
Yeah.
So again, was it a kind of bipartisan agreement for this one?
Yeah, this is a bipartisan. This bill, I'm not sure where Te Pāti Māori sat on it, but basically both parties are in general support of, on this particular bill. They're all in support, or both sides of the House, I should say. Te Pāti Māori, I'm unsure of, because I do know when they did the vote. I'm not sure of this one, when they did the voting, whether they actually had someone in the House, and I'm looking at the names, and none of the names are Te Pāti Māori. They're all National Labour, Greens. I don't even think there was even ACT in this one, but this was an interrupted debate, and this is day 2, where I think the better speeches came.
It's funny. I thought ACT would be really big supporters of being tougher on crime.
Oh no! I haven't looked at day 1 though, so that could be the interesting part. Is day 1